also to speak about Indonesian role in making of international law, whether or not we contribute in international making process. We will discuss in this seminar, and also various interesting topics. On behalf of the Islamic University of Indonesia and also our colleagues from the Faculty of Law, Islamic University of Indonesia, I would like to express our sincere thanks for coming, for your sharing your knowledge and experience in international law with us. And of course, we are very honored because of your coming here. And I hope that this international conference is not the end of our program. We wish that there will be the following programs with the cooperations, further cooperations in other areas. Thank you once again for your coming, for your sharing with us. And by reciting Bismillahirrahmanirrahim, in the name of God the Almighty, I formally open this seminar. Bismillahirrahmanirrahim. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Good morning.
Ladies and gentlemen, next is the signing of the cooperation agreement between the Rector of Universitas Islam Indonesia and the Dean of Faculty of Law with the DILA Chairman and also the Head of Postgraduate Program and DILA Chairman Korea. We kindly invite for the Rector and the DILA Chairman, also with the Dean and the Head of Postgraduate Program to come forward to sign together the cooperation program. Live streaming. Ladies and gentlemen, following the signatory of the cooperation agreement is the conferment of souvenirs from the Rector of Universitas Islam Indonesia to the DILA, and also DILA Korea. We kindly invite the Rector again to hand out the souvenir.
Terima kasih Pak Rektor. Terima kasih.
Ladies and gentlemen, with that, we have come to an end for our opening ceremony for this event. After the closing of this agenda, we kindly invite everyone to step forward to take a picture together. Thank you very much for your cooperation and attention. Good morning. Wassalamualaikum warahmatullahi wabarakatuh. Attendants to step forward to take picture together.
Sure. Cukup ya? Atau harus pakai kursi nggak? Wah, ya. Oke. Oke, nama seperti enggak boleh. Oke. Ya, Madani ya. Ya. Ini tentang yes. 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 Oke. Oke, thank you very much. Pak Rektor, thank you very much. Terima kasih, tadi kan. Oh, iya, please. Ayo, daftar, fotografi kembalikan dulu. Oh iya, ya Pak. Oh, masih ada lagi. Oh, lagi. Nah, apa tanda itu ada?
Thank you very much. Ladies and gentlemen, we would like to invite Professor Hikmahanto Juwana, Chairman, the Foundation for the Development of International Law in Asia, Professor of International Law, Faculty of Law, Universitas Indonesia, to deliver the welcome address. To Professor Hikmahanto Juwana, the time and place is yours.
Assalamualaikum warahmatullahi wabarakatuh. First of all, thank you very much all for coming here to Yogyakarta. As the rector has mentioned, that this is a city of culture, a city of students, and Indonesia, since Yogyakarta is a place where the heart of Asia or heart of Indonesia is. Secondly, I would like to thank the DILA Korea for the support for the DILA conference here in Yogyakarta, and also Islamic University of Indonesia, because without them, I think we will not be able to hold this important conference, and also tomorrow the DILA Academy and workshop. And with that, I would like to also thank the organizing committee, Pak Doding, and also Pak Chris here, who has been very helpful in having the conference hopefully be successful. Thirdly, I would like to say something that the importance of this conference. Last night I stated that this conference is timely because I think as the rector mentioned, the international community is in a changing environment, and I always said that this is going to be a new normal for the international community. We see how states act one to another, and I think international law is, of course, relevant. The question is, of course, what can Asia contribute to the international governance, the system, the rule of law for the international community. And that is why we will discuss topics on historical injustices and also the Islamic view toward international law, and lastly, the issue of making international law in Indonesia. And of course, last night I also mentioned that I think we need to have like what our colleague from Korea have done. They have established the DILA Korea. Hopefully, we will also establish DILA Indonesia. And the reason is because we need to spread the international law to Indonesia. And also, what we want to do is to have scholars from Indonesia to be able to voice the concern of Indonesia when we are discussing on international law. And also, we have a journal, the Essence Yearbook of International Law, which I think this is a forum for a lot of Asians to discuss on issues of international law. And lastly, I'm very grateful for the attendance at this conference, Professor Ko Swatsik, who is the founder of DILA, He has been at the beginning of DILA with Chris Pinto and also Wansik and Professor Tao is from Indonesia. And we are very proud of that. Thank you very much, and I look forward to a successful conference and a very productive one. Thank you.
Thank you very much, sir. Next, I'd like to invite Professor of International Law in University Law School, Korea, co-editor-in-chief, the Asian Yearbook of International Law, Professor Lee Sok-wook. Time is yours.
Assalamualaikum. Selamat pagi. Apa kabar? That's all I know. So, I'm very glad to be here. In Korean word, I believe that the Selamat pagi now is like the American say, okay, so that I'm very glad again to be back in Jogja again. Personally, this is my third time this town. As the new chairman of DILA, the Professor come talking about the background of the DILA to you. I'd like to talk about briefly about what DILA means and what we are doing, and why there are many delegates from Korea to attend this meeting. I participated in this DILA 2006 by the recommendation of my Professor Dan, the late Judge Park, to be involved, and I took over the chairmanship to 2012 the last year. And while I'm taking up this job as the chairman, what I try to do is that, as the also mentioned, disperse the idea of the DILA, so that doing many efforts to build our DILA activities in that direction. One of the main function I have to do is that the build of our publication, the flagship publication of the yearbook, and also maintain our annual conferences on a regular basis. So the DILA Korea is mainly working two activities. The one is the DILA, which is we have a meeting here, and the publication is a yearbook. And the other one is the APOIA, which is the Asia Pacific Ocean Institutions Alliance, that produced the two publication scheme. One journal is an Asia Pacific Journal of Ocean Policy, and the other one is a book series, the American Cooperation in East Asia. All the publications, you know, that are produced by the group, the NINO, which has a very historical link to our DILA community. I hold the meeting of the DILA annual conference back to 2010. Then in Seoul, as you may know that maybe Professor Swansig and the East Korea at the time when Professor Choi Tae-hyun was president of Korean Society International. And then we hold that the meeting at the Singapore and that the Eranga University Surabaya, and also back to the Korea's National Diplomatic Academy, and then the Hasanuddin University at the Makassar. And then by the very kind invitation of our Japanese colleague, we hold the meeting of the Japan, and also last year we hold the meeting in China. The main reason to hold this meeting around Asia is that we want to discuss the various state practice of the specific country, and then we back to the again talking about the as Hikmat mentioned that. Again, so that the main thing we already saw that the trend of these state practices such as in Asia in the last 13 years. So that the first week of October of next year, we hold that meeting, and I'm hoping that many people in this room also participate after us. We sometimes produce the publication like by the career, like a Northeast Asian perspective of international law, or Asian approaches to international and legacy colonialism. And those publication is a regular basis, but I think that this one is contributes the parts of our activities. We are very happy to report that the yearbook is produced on a very regular basis by now by the group. And the US open access, which means that if we go to the group's homepage, we can download the materials related to the yearbook without charges. And the other one is that I think the biggest the project right now we are working on the DILA Korea and the DILA SAC is that we propose the set up the study group at the ILA International Association by the name of the DILA, and also we propose the book proposal is the Encyclopedia of the Public International Agent. If you look at the most authoritative encyclopedia in this field is, for example, the Max Planck of International. If you look at the headings of that, there are not many headings cover the Asia. And I'm working with our member state. In DILA, we have a member state like about 20. And if the all 20 state members has the national the group like the DILA Korea, I believe that we can produce a very good outcome. We are working with our Korean colleagues to produce about 300 heading, so that at the end of the work, I really hoping that we can have about 6,000 headings to cover the very specific issues of the international in this region. So the publication company, the brewery, is very happy about that idea, but we have to see that how we materialize alliance is highly focused on the ocean and policy, and we hold that every year. But that is quite similar with what we had at DILA. That the member state in Asia Pacific. So every year we hold that we choose the different topics. For example, implementation of the UNCLOS in their states, or the national ocean environmental contingency plan, or the regulation of the irrigation of the 40 vessels. And this year, and also the maritime enforcement. And this year we hold that the 2018 April meeting in Sydney, as the side event of the ILA meeting there, and the topic is area-based marine protection in Asia Pacific. So the outcome, again, as I mentioned, that goes to the either journal or also the book series. And then right now that we have produced the volume 5 of that book series, so that from my personal judgment, because since the Apollo working on the very specific issues in ocean policy, the dynamics of the outcome is more productive, so that our DILA will catch up to see that the boats, the activities. And then inside of the Korea, the DILA Korea, we hold that our own workshop within the Korean colleagues, and sometimes we have European to invite the colleagues when they come to the Korea. So that is the overall brief introduction of what DILA Korea is doing. And since, as you know, that we are the 11 delegates here in Jogja this time. And when DILA Korea was built in 2015, we introduced the so-called study abroad program. So from the 2015, I think it's the Hasanuddin University, then Japan and China, and some to Jogja. We invite about 80 scholars to join with us to participate in this program. Because we try to invite the same people if the schedule is committed to go with us. Because the main purpose of this start program is to the international lawyers of Korea to know the state practice of the other country. We have many chances to participate in a conference, but it's a very rare opportunity to go to that specific state to deal with the international lawyers of that specific state. For example, this time we have chance to talk with the many Indonesian scholars, like what we did in Japan and in China and so that we have we continue this study and hope that state practice of the other countries express. And last word is that like the when Hikmal taking the chairman of the DILA, we are very much working together to this new generation of our activities. So that after he taking up the chairman, also the after I outgoing the chairman, we have a DILA constitution, very strict constitution. So we have although we have a member states about 50, we have only one board members from each state. Because this is not the association, this is a foundation. So board members is a little different with the opening other academic association, which is open basis. So we recommend the Professor from that himself, the sitting over there, as a new DGP members from Korean side, and that here take the many activities of DILA from the Korean side. And this is and also since I'm head of delegates from the Korea, the DILA Korea this time, I briefly taking up the brief moment to introduce this conference to the participants here. The first, I want to introduce the members, key members to working with me for the DILA state administration. The Professor Park Eun-kyung, he's in charge of all the administrative of the activities of DILA. And also, I would like to introduce the Serian Lee, female professor sitting over there. She working the international publication program of the DILA Korea. And I would like to introduce the delegates one by one from the right side. The Professor Kim Song-won, sitting over there. Can you raise your hand? Thank you. When you're working on the developments in Asia or any keyword, you may familiar with the term of the East Asia. He's the person to invent the term. And I'm hoping that through the various meetings, we can materialize the term he invented to us. So then next is Professor Woo Shijin, and he's a specialist on history of development. And Peggy Kim is also supporting administrative and structural development of Korea. And the next is Dr. Han Song. And certainly I already introduced Han Song. He's from the KMI, one of the sponsor, not the main sponsor, but this program. And then I choose the Professor Choi Tae-hyun, sitting over there, the senior scholar here. And he served the President of the Korean Society International 2011, and recently appointed the Korean government by the members of the Common Group of Arbitration, so that we will see that more of international activities in many places. And the Professor Shin Sang-min from the Korea National Diplomatic Academy, specializing in international environmental law, and also Professor Oh Seung-jin is they're working on the human arts. I think that is all the members we have here. And for the DILA side, the Royal Pastors, which might he is the executive editor of our yearbook, working very closely our DILA to produce the yearbook at the very own time. And the Kanami Ishibachi from Japan is one of the members. The brief introduction of the DILA and the DILA Korea. So thank you very much for giving me this time to introduce our members that with us today. So thank you very much. Thank you.
Thank you very much to Professor Lee. Next, I'd like to invite the co-founders, the Foundation for the Development of International Law in Asia, Emeritus Professor of International Law, Erasmus University at Rotterdam, Mr. Koswan Sik, to deliver the first keynote address for today.
Good morning, my good friends. I hope you will be able to hear clearly my effort to tell you something in English. My English is not good at all. I see, fortunately, there is only one natural or English-speaking person in this room, so that maybe criticism I will get for the word used and the words not used by me will only come from. The fact that I'm standing here, I'm fully convinced it's based on a misunderstanding. Because until a few days ago, actually until yesterday, I was not even aware that my name was on the program as a keynote address. I don't see the reason why I'm giving the keynote address. So, because it is a misunderstanding, and actually, I must say there was no understanding. I decided to interpret my arts. You know that interpretation is, of course, one of the most rough things we lawyers used to do. So I feel free to make such interpretation. Because there was no real motivation for me to come today here in the meeting. Because I have no functions and no responsibilities. And it was only a historical element for me. And I was happy to come to Indonesia again. And but I didn't know that I had some tasks to fulfill. The interpretation I give to my task is that I can only offer you some information so far as the historical element of the contribution of Indonesia to the development of international organizations is concerned. I've never been a politician that was involved in making the law. The only reason for the special interest I and my two other friends who founded with me the DILA, the special interest we had on state practice actually have its roots in activity by the Council of Europe in the early 60s, when they produced a declaration of state practice. And that declaration was then sent or post-distributed to the member states. At that time, I was working in Holland, as you know, and we had to do with that declaration. But we agreed that it was very important to publicize in a systematical way the practice of states in the their international relations, and so find out what actually could be considered to be practiced in the sense of the elements for customary law in the international field. You see the result of this approach actually to state practice, just not in DILA and not in the Asian year, because all these events with regard to Asia happened, so far as we were concerned, in the 1980s, whereas in the 1960s, we had to deal with it in Europe. And it was exactly that time that I was a person working there. It so happened that I was working in the Public International Law section of the University Institute in The Hague. We decided that it was necessary, especially for the state practice question, it was necessary to set up a new application. And so you see that in the early 70s, actually starting in 1970, there was a methodology of international law established. Actually, we established. And in that year, you can see that we started emphasis laid on the systematic publication of the practice of various states. We can so when in the 1980s we decided to start the foundation, we put a special emphasis on this state practice business. And you will see why, for that reason, the presentation in the yearbook is so very strong, I would say. And we know that in the early yearbooks, at least, when the three of us were still responsible for it, you will see in the first place the presentation of facts have nothing to do with legal interpretations, legal qualifications, or the facts of the by states which could eventually play a role in the formation of the law. That was one part of the state practice presentation. The second part was, as you know, you have to look at the early yearbooks. There was a section on international developments, actually international political developments, which might have influenced, or which might influence in the future the production or the realization of new international law. Then we have, as you know, a special section where we just documented without any legal evaluation the participation of Asian states in multilateral treaties. Rather special characterizations or characters of the sections which started were an element of the of the facts which later generations scholars could take to draw conclusions from these facts to find the impact coming up of new international law. So this has of course nothing to do with Indonesia's contributions to the development of international law. Whether there is such contribution, you can see after a while then having a good look in the course of the number of years of the facts which are documented in a sense as I have tried to describe. I hope that this little information can have some help for you from the future. Thank you very much.
Thank you very much to Mr. Koswansik. Ladies and gentlemen, next we will have a short coffee break for about 15 minutes. Please enjoy the food that we have provided outside. You may bring it to your table, and we will continue with our first session 15 minutes from now. Thank you.
Oh, iya, iya. Oh, iya.
Yeah.
Saya kira rasa lucu gitu, kecamatan ini orang rasa apa orang mengenal itu saja kan saya ya rasa saya kira rasa bukan badannya aja ya ibaratnya itu warnanya itu wes apa saya
cek 1 2 3 dicoba cek sound cek 1 2 3 dicoba cek 1 2 3 dicoba cek
Enggak apa-apa, biasa gitu.
You want to breathe? Yes, yes. You can. Please.
cek 1 2 3 dicoba
Sorry.
cek 1 2 cek 1 2
Ada Pak? Bapak di sebelah situ.
Ini juga manfaat juga.
Can I take out this?
Yeah.
Yang Pak beli, ini Pak beli. Pak gue ya. Di sini di mana? Sebelah sini. Saya tadi udah di sini.
Sini dong, dia mau
Oh, okay, no problem.
Kita kan, narik kabel sama kono kalau ini. Kabel, kita kan nomor. Kita kan nomor kita.
Assalamualaikum cek
belum terpasang.
Cek satu.
Ya, aku
Kamar. Saya kamar
Cek satu dua cek satu dua tiga.
ya. Aku share thank you. Kamsahamnida. Jam berapa besok? Mulai siang. Makanan apa? Senin itu. Jam 10. 9 tak cukup jam 10. Tak cukup jam 10 nanggung mobil. No.
Ya, sudah saya.
Yes. It's early 2000s, like 85. Yeah. Yes. Yeah. Was it the when you were
Orang
yes.
lain
Nomor siji more afraid. Yeah.
Misal. Ojo lagi contohnya ini. Samping dulu. Orang berapa deh? Nomor kecil. Yang peserta dari dulu yang peserta wajib
yang ini perempuan
Ditambah senilai
Ditambah
rasa soalnya anu tuh soalnya sinar itu
dia minta sama bentuknya nanti saya tanyakan. Ini nggak saya tambahkan nama Pak 01.
Tadi itu udah minta proyek itu nggak mau saat ini sampai sekarang itu step dulu.
Oh iya, ayo.
Kamu aja ya nanti tak tanya ke diri ya. Oh iya ini bagus, makanya ini kayaknya belum dia bagus itu kan saya baru nyantol. Ya, sebentar Pak, saya
Yang mana?
Tadi saya membuat tempat, ini ada
You print, the schedule is different than the one that we printed. So if I send it to you,
Okay, in the book, you may send
where should I send it to? What's that for?
email, I think.
For I don't think I have your email address. Good.
Inter dot pro inter pro
Pro.
dot law FUAD.
Yeah.
Printer.
I'm sending it to you.
Mau sini dulu Pak.
Sini sini. Printernya mana? Ini.
Iya.
Sampai berapa lagi?
Dia udah tahu soal yang lagi ya.
Chris, DILA.
Pardon?
You break my.
I know, I saw it. It doesn't work. Nothing works or just fried the.
Oh yeah, different.
This is the new one. Yeah. So what are we looking at today?
Can you print it?
I sent it to Vera.
Nanti print it.
So sorry.
Bisa di
So
print
here's
it.
the welcome address. That's the first session. You're both of them. You're the last session. Yes. I don't think that.
This is the latest one.
Yes, but I think they're the same regarding the surveyors. We had some people leave, so they aren't coming.
Because the land is slightly between the US some
Yeah.
So this one for me.
You want the
Yes.
the schedule?
Yeah.
Oh, she's pretty. She's gonna
She's
print
printed.
the schedule right now.
Okay. So he's,
Oh no! Wait, hold on. That's,
selesai.
Iya, iya, paper baru.
Next one.
Ya.
Semuanya aja Mbak, itu kan baru. Saya
Yeah, this is the last page. So the last page here.
Jangan.
Yeah, that's the last page. Yeah, this is the second page. 3 pages, 5 pages. What? Well, it's pretty.
Ladies and gentlemen, before we start our first session this morning, I'd like to allow Professor Hikman Kedwana to introduce to us all the participants from Indonesia.
Well, thank you very much. Because my colleague Professor Lee has introduced our Korean colleagues, let me introduce my Indonesian colleagues that are here. First of all, Pak Nandang Sutrisno, PhD, director, but actually we are very grateful, even though he is director, he is also an expert on international law, especially with the WTO. And he's going to present later on paper on Indonesia and the WTO. And currently, as you all seen, he is the rector of the Islamic University of Indonesia. Secondly, Ibu Dr. Randa Sriwardini, PhD. Over there, there we go, yes. She's also an expert on international law, especially international environmental law, and she's going to replace me as the chairman for the next session. Thirdly, we have our colleague Christopher Kaysen, JD, where's Chris? Over there, back there, there we go. Even though he doesn't look like Indonesian, but he's from the Islamic University of Indonesia. And then, of course, the man who is very busy and responsible with a lot of things, our colleague Dodik Setiawan Nur Herianto, PhD. He's expert in international law, also diplomatic and humanitarian law, and currently the lecturer at the Faculty of Islamic University of Indonesia. And then we have also Dr. Agus Prianta, PhD. Pak Agus, where are you, Pak Agus? He's outside. Okay, he's outside. He's currently the head of the postgraduate study, Faculty of Law, University, Islamic University of Indonesia. And he's also an expert on international Islamic law. He's going to present later on this afternoon. And then we have Ibu Ratna Juwita over there. She's an expert on international law as well. She's expert also in humanitarian and human rights.
and a lecturer at the Universitas Atmajaya, Yogyakarta. And probably you've seen yesterday, my colleague, Ari Afiansyah, PhD, who unfortunately has to fly back last night. So he would not be able to attend this conference today and tomorrow. And also later on in the afternoon, my colleague, Professor Melda Kamil, she's going to be here. She was scheduled to be here this morning, but oh, I got news that unfortunately she's hospitalized because she's currently 18 at my faculty, so she's my boss. But I think she's very tired, and unfortunately she's hospitalized. I hope that she will be able to recuperate by Monday, because then Monday is going to be a hard day also for the team. In any case, she texted me this morning saying that she will come only in the afternoon because she's going to present in the afternoon. But it is unfortunate that I heard from Adodik that she's being hospitalized. In any case, we will pray for her recuperation, fast recuperation, and nothing serious, hopefully. And of course, last but not least, myself from Indonesia. Hikmahanto Juwana from the University of Indonesia. So that is the list of the Indonesian participants. Thank you very much.
Thank you very much. Ladies and gentlemen, we'll start the first session on historical injustice and international law. I'd like to invite a lecturer of international law at the Faculty of Law, Universitas Islam Indonesia, who received her PhD from the International Islamic University of Malaysia, Dr. Nasri Watigasan, her PhD, Tennis.
Assalamualaikum warahmatullahi wabarakatuh. Very good morning, ladies and gentlemen, all the honorable speakers and all the professors here. So today, I'm mandated by Professor Hikmahanto to request him to be the moderator of the session. I would like to invite the first speaker here, Professor Song Hon Kim. If I mispronounce, please forgive me. Okay, then you would like to come here. And then the second one, Assistant Professor C. Dino. Yes, please come here. And then the third is Professor Seong Jin Ong. Give big applause to the other. We have time for 1 hour for the 3 presenters, so I would like to divide it into 3. So each presenter will be referred, let's speak for 15 minutes, and then the rest of the time it will be used for discussion. Okay, so we can start with the first presenter to deliver the speech. Yes.
Good morning, ladies and gentlemen. It's my great honor and privilege to be here as a speaker, and I extend my sincere gratitude to all this welcome hostess. And 15 minutes. Yeah, 15 minutes is enough for me. And I just summarize my series for you. Actually, this year, the 2008 is the 10th anniversary of the Australia, because the Australia is born after the 360 years of the birth of Australia. an email from the professors, especially from China. He said that your thesis of the East area is the ministry of the East area is another name of the Chinese version of the international law. So my answer is very clear. It's no. It's not the Chinese version of the international law. I think that you may be interested in what's the term of the East area is coming. I just changed some of the part of the West area. I slightly changed the West to the East. It's a double meaning of that. The first thing is that East area means the counterparts of the version of the international law with regard to the Western international law. The second meaning is that East means that East is the international law may be made by the Asian countries. That's for the only interest for all interests of the whole world. I think that the international law and the purposes of we always pay attention to the legacies of the injustices and the colonialism committed by the Western perspective of international law. I think you may also know about the extension of the Western version of the international law. It's heavily supported by the expansion of the colonialism and imperialism on the Western side. From now the 21st century, we don't have any instruments like the colonial and imperialism to expand the Asian version all over the world. So we can find any different way to extend our version of the Asian international world. I think that there are some two missions for this area. The first thing is that this area, the first mission of this area is to seek out injustices from the Western international law. The second one is that suggested a brand new version of the international law, mainly supported by some of the other ideologies such as the Asian element, the Confucianism, and the Islamic view of the international law. I think that the first mission of this area is to focus on the rectification of the injustices made by the Western countries. But this way of this area is not understood as a total negation of the Western version of the international law, because this area is operated only by the existing rules and principles of the international law made by the Western countries. So it should not be understood as the total attack against the international law of the existing rules and principles. And then why is the first mission is to rectify the injustices of the Western dominated international is that after the sorrowful compilation of the revealing the injustices of the international law, and then second step is rightly initiated. So to the extent that the aims to dig up the injustices involved in the West area, this is truly dependent on the monopoly or the hegemonic view of the Western countries. And then the new basis of the East area is rightly launched there. First thing that we may have lessons from the dynamics of the 12. You know that the 12 means that the third world approaches to the international law. Generally, the 12 is divided into two phases. The first one is 12.1, and the second is 12.2. 12.1 is some external revolution against the Western international law. The key factor of the 12.1 is restoring the state sovereignty and some clarification of the self-determination against the Western countries. But the failure of the 12.1 is that during the external revolution of the 12.1, some very basic rights are victimized by the first movement of the 12.1. But second, so the next stage of the 12.2 is that focus on the internal reformation of the third world countries. So at that time, the human rights and some environment is something like that is focused by the 12.2. So the East area project
as follows the dynamics of the trade movement. So the first thing is that, as noted earlier, revealing the injustices and the hegemonic structure of the international law, and the second one is that suggests some new fresh look or fresh insight from the cultural history of the Asian countries to expand these ideologies all over the world. So, and then you may, I think that you should remember that the main reason, the failure of the 2-in-1 is that at that time there's some informative insight suggested by the third world, but there is no actual ability to realize or crystallize the ideas from the Asian countries. For example, the neo and then some of the deep sea authorities regime is proved as the failure of the third world against or revolts against the Western countries. Now it's the vice versa. The Asian countries has some of the material powers and the cutting technologies, and the Asian countries is proud of the increasing the material capabilities in international relations, but just to increase the material capabilities can be the necessary. Asian countries, that the social condition is that is supported by some new philosophical and cultural thoughts for the international society. And so that, for example, there's also Confucianism from China, and the new Asian values. Asian values is hardly affected by the Western countries because it goes beyond some collective social right, and it is not the focus on just an undemocratic government system in the domestic relations. But this is I think that the new version of the Asian values is welcomed by the whole of the world. Only to focus on the openness and the justice of the international relations. I think that you may have some question about the injustice from the international law. Let me introduce my colleague, Professor O. He is the actual born assassinator of the Western countries international law. So if you have any question about the injustices, please ask again. Not me. And then the Professor Saduri asked me to say that or refer to the footnote 21. Footnote 21 is that some papers is presented at the annual meeting of the Asian the Korean Society International Law. This paper is made by Professor O and Professor Lee, and that paper refers to some remarkable approaches from the judges from the ICJ. He cites the separate opinion about the Professor Ranjiba. He says that some territorial and maritime disputes should be reviewed by the perspective of the cultural and the historical origination of the dispute. For me, that is very strongest and weaknesses with regard to the hardcore program of the Westphalia system, such as the territorial or maritime dispute. As noted earlier, the Westphalia project is not possibly operated without the rules and principles of the international law, existing international made by the Western countries. So that hardcore principles of the Westphalia, such as territorial and maritime dispute, Westphalia has the answer. Westphalia may answer to that apologies. We don't have any instrument to settle down this problem. But I think that the historical and the cultural aspect of the territorial and maritime conflict is, I think that deliberately discarded by the Western countries. So that the first mission of the Westphalia is to highlight the true origin of the territorial and maritime dispute in terms of the cultural and the historical issues. And the second one is that the future direction of Westphalia is that, for example, I think that it is the most interesting object for this area is that the human security issues. Everybody knows about that. Oh, this is a 5 more. 5 more. Okay. I think that you may know, or you may all know about that. The 2008, I remember is that 2008, the cyclone Nargis is devastated the part of Myanmar. At that time, the international society urges the international society to support the humanitarian relief to Myanmar. But at that time, the Asian countries has some stubborn position toward the support of the Asian countries to support the Myanmar because we do have the state sovereignty, so we don't want to be intervened by the outside countries to our place. So that scholars from the Western countries, and I'm not a Western scholar, but including me, that there is no version of the responsibility to protect the Asian perspective. Because that the Asian countries seems to stick to the supremacy of state sovereignty. But I think that the post-Westphalian era, this is the salient characterized by this international to moving to the more people-oriented or more just openness, so that if the Westphalia may still stick to the state sovereignty or something like that, the Westphalia should not be welcomed by the whole of the international society. So the Myanmar case is the leading case for whether the Westphalian project is turn out to be a successful or a failure. The chairman gave me the 5 more minutes, but I think that the 5 more minutes is not necessary for that. So I just put myself that. So again, the Westphalian project is not for the Asian countries only. Think about why we are angry about the international law, the existing international law, because this is made by the legal mechanism for the European countries and the Western countries only. So if we strongly argue that this area should be put the first interest of the Asian countries, and after 300 years later, the Western countries had this conference for taking this matter. So my conclusion is that this area is to all of the international society, not for the only Asian countries. Thank you for your attention.
Thank you. Thank you very much, Professor Songwon-Kim, that you bring us to the new philosophy of international law, which would like to change the domination of Western philosophical in the term of international. So how we would like also to introduce our philosophy in the international community. Hopefully that your opinion will be get the supporting also from the ASEAN countries. Okay, thank you very much. And now we come to the second speaker. Assistant Professor CEO. Okay, thank you. So the time is yours.
It is my great honor to present my paper at this meeting. Today, I'd like to discuss about relevance of history and theory in the historical injustice issue of East Asia. Therefore, unfortunately, I'm not going to talk about assassination of Westminster in Venezuela. Anyhow, discuss the issue of historical justice is not an easy task. The question of justice on the international level is not a central subject matter, at least in the realm of international law. Moreover, the universalized international legal system is based on legal positivism, which distinguishes law from morality. Therefore, justice is not a popular topic to discuss in the mainstream international legal sphere. However, the historical justice issue may be presented on a structural level. Previous perspective seems to have often neglected some significant aspects of the development of international legal order or universalization of international legal order. International law has extended over, conflicted with, and coincided with different international legal orders. This structural issue seems to be one of the premises that has not been dealt sufficiently. The complexity of such historical conditions demands questions. This paper, this presentation, suggests that the historical and theoretical aspect of the development of international law is relevant in the discourse of historical injustice issues. The study attempts to point out that there is a structural issue in relation to historical justice. However, this does not attempt to deconstruct the validity of current international law or demand reparation for each historical wrongs. Rather, it attempts to contribute to the progress of international law by appealing to the theoretical questions of historical injustice issues. The first question that I like to ask is that what makes the application of Western international law legitimate in historical cases in the name of intertemporal law? The relationship between intertemporal law and legal positivism has to be defined. There are some, regardless of their, actually, a version of legal positivism was universalized in the late 19th century. However, not many points out that such version of Western international law itself may have caused latent issues for concern. In other words, the universalization of Western international law based on legal positivism may have a side effect. Intriguingly, many of the current international legal issues in East Asia are connected to unresolved historical events, especially those of the 19th century and early 20th century. I have some examples, but because of time constraints, I'm going to skip that one. Indeed, East Asian nations are fervently discussing the unresolved issues within the framework of Western international law. However, historically convoluted issues of East Asia demand questions on the legitimacy of international law in the past and today. The imperial character of the classical international law was noted. Applying the international law may not be unobjective indeed despite its claim. What makes it confident that the applying international law is not justifying the practices of the previous imperial powers. This aspect seems to have been frequently been noted by previous studies. However, there is an aspect that has not been sufficiently discussed yet. A formalistic approach which disregards the context of the application is questionable, because the legal positivist thesis of law states that law is confined to the social space it is applied. Legal positivism, the attributes of legal positivism have two aspects. One is time-specific aspect, and that has a repercussion to intertemporal law. Another aspect is space-specific aspects. Therefore, law is constrained in space and time. However, I consider that many of the studies seem to have neglected the space aspect. What then is the social space of the Western international law? I point out that the Christian context or social space of the Western international law has to be noted. The development and establishment of formal equality of state must noticeably refer to peace of Westphalia, be seen as an establishment of initial stage of the formation of the legal idea based on Christian religion. As Grundnorm of the international order, sovereignty in Baudin's original proposal was referring to Prince, who is the image of Christian God. Hugo Grotius was referred as the one who severed the theology from international law. However, that's not exactly true. Siding with the Aramean theological perspective of free will, Grotius' thesis of international law was still in the boundary of social space of Christian ideas and culture, though it was altered and transformed. In the 19th century, Witten's Elements of International Law, 1836 version, defines international law as understood among Christian civilized nations. Oppenheim, in his 1912 version of his textbook, notes that the civilized states are, with only few exceptions, Christian states. Oppenheim first stated that their civilization is essentially so different from that of the Christian states that international intercourses with them of the same kind as between Christian states has been hitherto impossible. Moreover, in East Asia, Christian missionaries introduced these secularized Christian international orders. For example, William Martin, an American missionary, translated works of Witten, Woolsey, and Bletchley into Chinese, and soon those texts were introduced to Japan as well as Korea. Guido Verbeck, a missionary from Dutch Reformed Church, taught Constitution of the United States and the international law to Japanese samurai and government officials, and founded the University of Tokyo. Of course, not many would claim that the 19th century international lawyers and the Western government pursued religion or Christian religion or any kind of religious schemes. However, an aspect of legal positivism which emphasizes the social space of law's jurisdiction cannot disregard geographic or social space of law. Therefore, the qualitative differences of the social space of law in East Asia should be noted. Despite the complicated theoretical issues, the East Asian nations seem to have in part accepted the Western international law as a rule of law. However, that's overgeneralization, because China, Japan, and Korea had different policies of accepting international law. China, for example, at the time of Qing Dynasty, seems to have denied the relevance of Western international law at first. China did not consider itself to be bounded by Western international law. It was utilized and used to govern the others. In Korean term, in Chinese term, which I only know is in Korean pronunciation, it was EEJE, controlling foreign countries by using other foreign countries. Therefore, international law was a rule for Western nations, not East Asian nations. Japan was very proactive in accepting Western international law. In Chinese terms, it's Talai Gu, well, the pronunciation is Korean. It's to leave Asia and to enter Europe. Korea, on the other hand, had a different policy, which was Dongdo Seogi, which is a dualistic policy that stands with the idea of Korea should keep the traditional way of East while learning or utilizing the Western knowledge. So there are variations in accepting Western international law in the 19th centuries. How can we, in such transitional state, how can we say that the Western international law was the legitimate governing rule at the time? Confucianism is another complex system of normative order which provides symbolic meanings to the followers. Li, or rules of ritual behavior based on hierarchy, was an instrumental governmentality of the traditional East Asian order. Moreover, like natural law counterpart of the West, the Li was based on cosmology, a normative order of Tao of the universe. The encounters of the East and West here could be seen as a conflicting and overlapping formative context of different legal systems. Accordingly, the applicability of jurisdictions in question was in question. Strictly speaking, the Western law at the time did not have jurisdiction over non-Western cases. What about the case of interaction between Western and Eastern nations? Why did the Western standard prevail in such cases? And this kind of issues concerns with historical injustice. However, I'm not here to, as I mentioned before, I'm not here to deconstruct Western international order. Instead, I attempt to contribute to the development of international law by providing questions. What justifies the monopoly of Western heritage of the international law in the Western and non-Western social space? These questions may contribute in providing a different perspective to the international society, including that of the ICJ in taking historical cases, especially in East Asia. The truism of intertemporal law in the application of the contemporary international law has a structural issue because it reflects the social aspect, the place aspect of legal positivism. In other words, the validity of law is bounded by the social space or geography. Apparently, there are ways to approach this issue. It may be advantageous to perceive the subject matter in a productive light. Is there anything to learn from an alternative theory or view of the past and present? This does not imply that the ancient Sino-centric tributary regime should replace the present order of equal sovereignty. Previous tributary order cannot be revived because it is practically impossible and normatively problematic. However, there is another reason why such order cannot govern us. It does not reflect the East Asian values any longer. Nevertheless, the present international legal order may benefit from non-Western reasons. More importantly, however, the voice of the unheard, the minority vote should be noted. The future of international law and the legal order cannot be monopolized by just one culture and identity. A sophisticated reconstruction of legal beliefs may be necessary to imagine a new international community encompassing different yet virtuous ideas and values. It is essential to reaffirm the statement made by the Western Sahara Advisory Opinion 1975. Says, no rule of international law, in the view of the court, requires the structure of a state to follow any particular patterns, as is evident from diversity of the forms of state found in the world today. The possibility is open, and the productive imagination is necessary. An inclusive plurality in which acceptance and difference plays a role should be a task of the next millennia of international legal order. The Eurocentrism excluded the non-Western ideas and ideologies in the past. Accordingly, the universal international legal order has excluded the others in the history of Eurocentric international order. Now is the time to shift the paradigm for more inclusive legal universal order in which even minor voice could be heard meaningfully if it is relevant and beneficial to the development of international law. Thank you for listening.
Thank you very much, Assistant Professor Sikiko. This is very interesting presentation because you want to change about the legal consideration with this protocol and informational. They don't, at the time being, that they didn't consider about what is the contribution, especially for the Western countries in ASEAN countries. So that how we would like also to contribute to the development of international law. You mentioned that you don't want to deconstruct about in the Asian countries such as Korea, China, and also Japan, and also maybe Indonesia, but to contribute to the development of international law. And know that we are the newcomers in the international community, but we are going to also contribute to the development of international law. Thank you very much for this kind of idea. This is a good idea for us. Again, that's all the last, but please, if you would like to say something. Yes, sure.
Yes, my
Mas Agung. Oh, slide-nya. Mana slide-nya? Sudah. Oh, yang tengah. Ini gimana? Jadi coba gue cek. Biasa. Gue kanonnya. Apa ini? Tapi aku ngerti dong. Oh ya. Ini nih Pak. Iso. Ini aku berkomplain Pak. Oke. Dia ngomong gitu. Harus ngomong ngomong. Nah iya. Asal. Nah, kalau main foto sama main foto. Tapi kita mungkin berangkatnya ini. Itu termasuk itu. Sama ini. Gantinya hah? Ini kan speaker. Nek, oke. Ini wong. Oh, anaknya. Harus ngomong kok. Oh. Ya mau.
Okay. Okay, Professor would like to start with the introduction because I am waiting for the preparation.
Okay, thank you. When I first heard the topic of my presentation, I just wondered whether history could be just or unjust, and what it means to be just in history. So I'm very glad to have this opportunity to look, to study on this topic. As you know, East Asia is fragmented, as I understand, multilaterally fragmented. Economic, of course, economically, East Asia it has been increasingly integrated, but politically, East Asia is still divided. China versus South Korea, Japan, and the US. And historically, China and South Korea on the one hand, and Japan on the other hand. And still, North Korea is isolated, mainly due to human rights violations, and nuclear weapons programs. Fortunately, yesterday, North Korea announced that they would destroy nuclear testing sites and would not test ICBM anymore. That's I think good news. Historian, according to historian Carr, he defines history as a continuous process of interaction between the historian and his facts, and then an ending dialogue between the present and the past. No. And he mentioned that the historians shall not pass moral judgment on history events from a current moral perspective. But philosophers always have had an interest in the matter of justice. According to Plato, justice is established when everyone performs his job. And Aristotle mentioned this famous phrase: equal shares to equal persons and unequal shares to unequal persons. Hobbes argues that injustice means not performing a covenant, and Kant suggested a theory of justice based on a social contract. John Rawls, on the other hand, suggests his principle on the matter of justice. He said that justice is the first virtue of social institutions. And according to him, laws and institutions, no matter how efficient and well arranged, must be must be reformed and abolished if they are unjust. And he suggests two principles on domestic justice. The basic rights and duties should be assigned equally, and social and economic inequalities are just only if they result in compensating benefits for everyone, especially for the least advantaged members of the society. On the matter of global injustice, this issue has been relatively neglected. But according to Ratner, international law rules are just or if they advance international peace and respect basic human rights. Before 19th century, international, as you all know, international law was a product of Christian states of Western Europe. Therefore, according to Thomas Aquinas, what could be justified with only a just cause. And Grotius argues that the law of nature would be valid even without God. Positivism dominated in the 19th century. Therefore, international law was based on state's will, and no substantial political or moral issues mattered during this period. And this period is a period of colonialism and imperialism. And also, international law during this period was based on civilized Western states, and a just cause was not necessary to wage war, and human rights were not a matter of international concern. Before the arrival of Western powers, China established a tributary system in Asia for many centuries, and Japan relatively remained isolated before mid-19th century, maintaining minimal commercial trade with other countries. And therefore, Western states also had to accept this established traditional tributary system to trade with China. But in mid-19th century, the Treaty of Nanjing after the Opium War opened China in 1842, and the Treaty of Tianjin and the Beijing Convention the opening of China. And in the 1895 Shimonoseki Treaty between China and Japan, signed after the Sino-Japanese War, and the traditional Chinese tributary system. According to this treaty, China recognized that Korea was a completely autonomous and independent state. But the treaty did not make Korea an independent state, but paved the way to losing its independence by Japan in 1910. Also, the treaty made Taiwan a Japanese colonial until 1945. On the other hand, Japan opened its gate in 1854 to the US by signing an equal treaty. But Japan was eager to enter the Western civilization. In 1876, Japan forced an equal treaty to Korea by force. Korea was opened by the Japanese military threat in 1876, signing an equal treaty. And Japan incorporated Tokyo Islands in its territory in 1905, which had been considered a Korean territory for centuries. Japan, in 1905, signing a treaty with Korea, deprived Korea of its diplomatic power and made it a Japanese protectorate. And in 1910, Japan annexed Korea by an annexation treaty and occupied it until 1945. Before World War II, at the end of World War II, the World War II, the international order in East Asia was shaped mostly by unequal treaties. Almost all major treaties that had shaped the East Asian order were obtained by threats or use of force. But after the war, the decolonization process occurred. The 1943 Cairo Declaration declared that Japan would be expelled from all territories taken by violence and greed. But Korea was divided into two by the US and the USSR since 1945. And China is still separated since 1949. The 1951 San Francisco Peace Treaty and bilateral treaties after World War II aimed to officially end the war, failed to settle all legal issues concerning Japanese colonial occupations and invasions before the war, including territorial and comfort women issues. On the legality side, this principle is I think, has been accepted. A dispute should be resolved by the law effective, by the law effective when the dispute arises. The declaration, for example, the Declaration on Principles of International Law concerning Friendly Relations and Cooperation says no territorial accusation resulting from the threat or use of force shall be recognized as legal. But on the other hand, the declaration says any international agreement prior to the UN Charter regime and valid under international law shall not be affected by this. Shall not be affected. But on the other hand, justice side, jurisprudence does not allow any derogation by means of treaty or customary rules, and as you know, Palma's case said a distinction must be made between the creation of rights and the existence of rights. The existence of the rights, in other words, is continued manifestation shall follow the conditions required by the evolution of law. So according to this principle, the states are required to conform their behavior activity to the ever-changing current international law. We think the domestic legal system is natural. Natural thing that laws are enacted to rectify past injustice. Bruce Cummings, a well-known scholar on Korean history, was commented on the first so-called modern treaty signed in 1876 with Japan. That what might modern mean, modern treaty? Does it mean fair treaty, or does it mean equal treaty, or was it concluded in accordance with international law, or was it concluded by sovereign states, sovereign nations? But in fact, it was concluded in the name of sovereign equality and against the traditional hierarchy of the Chinese world order. But the real effect of the treaty, so-called Mother Treaty, was to erase the centuries of essential equality between Japan and Korea and paving the way of losing Korea's independence. History itself is not just war and just, but in my opinion, law should be based on justice, and law should be about justice. International law should be should be based on justice as in domestic legal order. If international communities legal community should be naturally based on justice. Global justice must promote peace and respect for human rights. Colonial issues in East Asia must be settled based on global justice as far as they affect the current state's relation. Thank you very much.
Thank you, Thank you very much, Professor Sinjiho. That's you already explained to us and share your knowledge regarding how about injustice has been created in the before the First World War, and even this is long time ago before the First World War, and also is continuing until before the Second World War, that they adopted by Korea, Japan, and also with the Western countries. That even that's there would in international there is recognition of equal position between states, but this still in theory at that time. After the Second World War, then the little changes about the recognition of principle of equality between states, but this only still in the formal or in the declaration of the United Nations declaration. But how about in the reality that we still need to develop and also to struggle to maintain about justice? What is justice? Various meaning of justice. So how justice according to Western countries and justice according to the ASEAN countries, there's some kind of different because we have different value with them. So how does the ASEAN countries would like also to propose about justice is used, how to protect the interests of the whole community, and I'm interested in the last statement that the global justice here it should be proposed also how to protect the interests of the whole state and also the justice for every state in the world. It's not only for the group of state which has some kind of domination in the international community. Thank you very much, Prof. And not the session, but before we continue with our session, I just want to make confirmation with the committee because now it's already 11:30. So what time that we are going to end this discussion? 12. So we still have enough time for 30 minutes. So the time it will be used for discussion. So maybe there are some comment or would like to ask some questions to the presenters here. Okay, can you please mention your name?
Thank you for the presentation. Very interesting, and I really enjoyed hearing your presentation. So I have 3 questions. One for first for Professor Kim Sung-hwa. The concept that you utilize and actually embed the Eastalian concept. So based on this area that you used, it seems you try to point out the different concept or understanding of the principle of sovereignty, but at the same time, it seems you try to point out the changing understanding of the concept of the sovereignty. So could you elaborate a little bit more? You try to highlight differentiate the principle of sovereignty or the changing of concepts. Actually, it is also related to the development of international law on the concept of sovereignty. Second question go to Professor Oh Shijin. Also very interesting to see in your highlight the social space understanding sovereignty in international law. And you also indicate some of the historical injustice issues, especially the Northeast Asian states. But what's the implication to today's international legal system? So, from your empirical study or historical analysis in the 19th centuries among Northeast Asian countries, so what can be the implication of that to today's? And also, you use the term the universal international legal order. So, what do you mean by the universality of the international legal order? Usually, you use the international legal order, but the universal, it seems you think certain universal norms like the World Constitution but from the legal politics point of view, this concept is the critical element, right? So I'd like to hear a little more on that. And last question go to Professor Oh Seung-jin. You described the unequal treaty, but it's among Asian countries, not from between Asian country and Western country. But at the same time, you talk about the global justice that personally I'm not really comfortable on using the term global justice, especially thinking on human rights issues. So I'd like to hear a little more on that. Actually, you talk about the jus cogens norms, the violation of jus cogens when you point out in your previous slide, but is it linked to the original treaty? I do not understand the link of that, so I also want to hear on the issue. Thank you.
I think that we can directly to answer the question, or would like to have such kind of argument that you would like to propose to the. Okay, so
Thank you for the back. Professor, just to raise a question concerning to the meaning of the sovereignty. I think that every international lawyers spend the whole year for explore the meaning of the state sovereignty. So this is not. I think this is not my ability to answer in terms of the meaning of the state sovereignty. But I think that my understanding is that Stefan Kressner categorized the sovereignty as a four parts. Last one I can remember the domestic sovereignty and the international sovereignty and the Western sovereignty. Last one I was missing. But I think that the sovereignty, the Professor O and another Professor O already mentioned about the meaning of the sovereignty is changing from the time and the space. Professor Shijin rightly point out that certain meaning of the terms of the international law is the mainly shaped by this certain time and a certain space. Means the specific time and the specific space always influence a huge effect on the meaning of the international law. This is still already mentioned by the Professor Martin Scaniani. He said that everybody knows about the sovereignty is important, but who doesn't raise any question about the meaning of the sovereignty is originated from the certain space and certain time from the 17th century. Space is the restraint to the European countries. So that we just wanna. I just want to think about what is the meaning of the sovereignty in the 21st century under the globalization. Professor Beck rightly pointed out that you use the state sovereignty for the Eastphalian project, but you also use the state sovereignty as some of the new blueprint for the new direction of the Eastphalia. As I already mentioned about that, the Eastphalia is not afraid to be of the religious symbols and questions of international law by the Western countries. At that time, the Eastern hold some debating factors of the state sovereignty. But my argument is that I think that the prospect is the only one expert is the exaggeration that only expert in the human rights in Korea. And I think that he is focused on the relationship between the state and people or individuals in terms of the human rights. I think the 21st century we redefine the meaning of the sovereignty because the two salient feature of the sovereignty is the supremacy in the domestic politics and the independence against the outside intervention. But what is the real sovereignty? I think that the sovereignty is devoted to the protection and the promotion of the human rights in the domestic or international relations. So if the state stresses sovereignty, not focusing on the promotion of the human rights in the domestic affairs, I think that this argument cannot be held anymore because the individuals in this regions. So I think that the Italian version of the human state sovereignty is to develop some of the instrument cutting off. This is a radical argument about that, cutting off the relationship between the state and the sovereignty. This is an attempt to make a new way, well, like a pavement for the new path for the linkage between the human beings and the sovereignty. So that in brief, that the 21st century, the sovereignty without considering the human rights does not take it any longer by the international society. I think this is not the right answer for your question. Thank you for your question.
Thank you, Rob. Next, please.
Thank you for the question. Perhaps I didn't have much time to elaborate myself on those points. Very good questions. First of all, the implications to today's situation or international law. The thing is, I consider the ICJ and all the international legal discourses today are more concerned with intertemporal law, and that's just one aspect of or one attribute of legal law or legal system. There's another aspect which is if I may coin the term, there's interspatial aspect. I'm not the first one who point to that question. Actually, in his separate opinion of the Cameron versus Nigeria 2002 case, Judge Al-Khashane criticized the concept of intertemporal law. He says intertemporal law is general in its application, its underlying rationale and unity of purpose being time, temporal, as its name implies, not geography, and cannot be divided into regional intertemporal law. All the more so when no state in the concerned region, be it Sub-Saharan Africa or Southeast Asia, participating in its formation. In other words, the intertemporal law is also monopolized by European international legal order. And I consider that the interspatial aspect has to be included in our legal discourse. I consider it has been neglected for a while. The second question that you have mentioned is about universalization of international order. And I consider this is also related to the first question as well, because the universalization of international law, according to many legal historians, it happens in the 19th century. When was the time the international law was universalized? 19th century. They mentioned that. However, we do not point out the fact that universalization was also a monopolization of European international law order. What I'm trying to say is that universal order has to be more inclusive order rather than exclusive order by one common civilization. I hope if I have answered your question.
Thank you. Next.
Okay, thank you for the question. of course, we can use the phrase international justice instead of global justice. What I meant by using this global justice is that we naturally we think it's natural that law should be based on justice, as in domestic legal order. But we do not think international order should be based on justice. I don't think it's good. And second question is jurisprudence linked to unequal treaties? Of course not. Unequal treaties do not exist anymore today. When I mentioned the use process concept in the context of unequal treaties, the use process reflects the justice given in international order. Justice exists in international relations, and law should be law assumed, I think, international community, and the community should be based on some kind of justice, the concept of justice. That's
Okay, so if there are some questions you'd like to raise, please.
First, before I raise a question, I would like to thank the speakers. It is really a very thought-provoking session, and I learned a lot. So thank you for sharing. My name is Dole from the University of Wollongong. My question actually to any member is: do you think, as the global as the world shifts from Europe to Asia, and we're seeing this not just in the economic sphere, but also in terms of politics, politics and international relations. Do you think international law as defined by Europe, or that Eurocentric view of international law, will shift also here? And given that shift, do you think, and is it foreseeable that in the future, this part of the globe will now be dictating international law instead of the powers that be that were, of course, in the olden days were European and the Americans? And I ask this question specifically in the context of, for instance, the South China Sea, where we see China almost to the point of breaking international law, quote unquote, because they're not following the Arbitrage Tribunal Award. But more on the realistic and practical sense, do you think the shift, the signification, the shift in global power to China in this part of the world would also mean later down the track, maybe 50 years or a century from now, China being the global superpower, hopefully by that time, will now be dictating international law such that being the most powerful state, it will not be breaking international law, but now making its own international law, and that international law will be the global, universal international. So in essence, my question is, does the shift in economics, the tilt of global power, do you think if we follow this projection would also mean in the future that international law would shift here and the Eurocentric view of international law would be abandoned because the most powerful states will be in this part of the globe, instead of being reactive and looking at injustice, will be on the other side of the fence, meaning the people in the West and the European views will now be abandoned, and now at the proper time, the eastern sides or the eastern side of the philosophy or ideology or theories of international law will become the dominant international law. Thank you.
Would you like to your name, please?
Lola Bautista from University of Wollongong.
Thank you. The next, please. Would you like to a question or comment maybe from this side? Okay, thank you.
My name is Lee from Korea, and unfortunately, the practice of my neighbor, I'd like raise a very short questions to speakers of this panel. the first question to Kim is that, as when I introduced him, when he wrote his dissertation, he invented the term of the Ispalia almost 10 years ago. I was just curious that over the last 10 years, how do you yourself evaluate term of the Ispalia, the prevail, or the more methodology in comparison with the term where you first time to think about? And the second question to Professor O, the junior O, is if you listen to your presentation, you're talking about the many international lawyers, particularly Western scholars, right? And in particular, we hold the conference here in Indonesia with the cooperation with the ULI. I was just curious that when you talk about Christianity or the East Asian perspective, when you read the materials you work on your paper, any materials touch upon how they evaluate the Islamic culture in terms of the development international? I just want to be curious about that. My last question to Senior O is that I think this question is quite similar with Professor Beck is in terms of the global justice. When I hear your presentation, I'm just curious about the regional implication of the term of the global justice. Do you have the regional justice vis-a-vis the term you use, the global justice here, either in East Asia or in Islamic countries? So that's my replication to the speakers.
Okay, thank you very much. But before the president would like to answer all the questions, so we already have 8 minutes, so it will be divided into 3. So please be free to answer the question. Okay, Prof, you are the first.
First of all, as to the question from Professor Lee, what I argue in this presentation is, of course, you may argue based on different concepts of different ideas on the matter of justice, but I just argued my presentation based on global justice, based on human rights or peace. But I think different ideas could be argued, but my main argument is justice should be important, should be dealt with importantly, as in domestic legal order. Okay? So different ideas could be developed, I think. And that's my first step. And the question from of course, international law has been dominated mainly by Western powers. In my opinion, of course, China is trying to readjust or change the existing legal order. But I think it doesn't. The fact that international legal order has been dominated for many centuries by Western powers does not mean that China can do anything to change the existing legal order. That we should find some common basis, common grounds to change, to readjust the existing legal order. Of course, in a sense, that common ground could be found from the concept of justice, or in a sense, that could be my. Thank you.
Okay, the next will be you, please.
Okay, thank you. First, Professor Low from London. I consider that shifting to Asia, economic, political, well, we do not know what will happen in the future. We are not futurists, so we have no idea what's going to happen. However, China's approach, I think, is mistaken. China's approach is going back to the old days. 9-day shrines, perhaps it was valid back in the old days, but not today. What I'm trying to what I'm concerned or what I'm interested is reinterpretation. Well, the international, the Western international law might have been originated from the Western countries, but that does not necessarily mean that we cannot accept it. We are influencing, the history manifests that any cultures are influencing each other. The civilizations can be changed and it can be reformed and it can be influenced by others. It's okay. What I'm more concerned is the unheard voice and the monopolization. What I'm trying to say is that in the future, what may be necessary is a qualitative transformation of international legal system that can encompasses and be more inclusive system. And I will try to answer to Professor Lisa Wu's question about Islamic culture. I consider that, well, I'm not an expert in Islamic international law or Islamic legal system, so please enlighten me if I'm mistaken, and I'm not trying to get any kind of impression here. However, from what I have read is that the Western identity has been grown up and has been constructed in comparing and contrasting with the Near East, more specifically Islamic culture. Therefore, Islam has been the key others for the Western cultures and Western Christians. If you go to European nations, each European nations actually do have different cultures and they're very different from each other. However, the Islamic culture was so different from the Christian cultures. They were the key others, which formed their own identities as Europeans. And that's also very important aspects of the development of the Western civilization, I consider.
My first answer is given to the Professor Reed. You just mentioned about the 10th anniversary. What's going on with the experience development? This is the most common question is put to me that I think that the definition of the meaning of the Eastern is used by the Western scholars and such as the Simon Chesterton or the Tom Ginsburg. But they are not aware of what the exact meaning of the Eastern. As I noted earlier, that they think that the Eastern is another name of the Chinese version of the international law. But so I emailed the Professor Simon Chesterton and the Tom Ginsburg that this is the most horrible misunderstanding of my article, and they say that resend me your article. So I think that 10 years already have passed. That I think that from the international relations studies, and they are focusing on what's the future direction of this area and something like that. But in the legal terms, it's not fully supported by some kinds of the international lawyers, because that seems to be the more radical and more critical attempt to change the whole structure of the international. But Professor Young already said that this party does not want to make us the radical system from the international law from this time. And this is the answer to the Professor Lee. And Professor from the Orlando, do you name is No, sorry about that. I think that you raised a very big and most important question for all of us. Both of the professor, or the younger one and the senior one, already said that we do not expect to the international law by China. But I have some slightly different opinion about that. I think that nobody knows about the future direction of international law by China. And the professor said that the 90s line is always a terrible interpretation of the law of the sea. But we are now dominated by the Western system 360 years ago. So that we do not know about what's happening after 300 years later. So, but I think that we don't know about the power politics of China. But only thing I know is that the international law is affected by the powerful countries, great powers. So the Australia or our future direction of international law is to find out the hegemonic attempts of the great powers I think that Asia may make a huge contribution to some international law, brand new international law is based on the openness, justice, and something like that. But I think that one of my colleagues said, you know the meaning of the self-contained regime in international. Yes, I know that the self-contained regime is specified in the WTO or the human rights, something like that. He answered to me that no, the international law is the self-contained regime of the Western countries. So, my answer is, so do you want a creation of some Asian international law, Islamic international law, Latin American international law, something like that? He said that is not possible, but this is my great picture about the truly international society has the last version of the international law, but this is not my art. We just try to find out some of the hegemony or injustice setting of the international. Who makes the international? Whoever made that. So the Asian countries will make a great contribution to reveal and herald there is something wrong in the dynamics of the international law made by the great powers. Regardless of the China, by Korea, Japan, something like that. So the future direction of the international law for me is that we just turn the hours from the power focus to the power focus to something. Power focus to reveal and detect some hegemonic attempt or some hostile attempt to reveal powers to. They are in disguise of this. So how we are the shape of the international. This is my answer.
Okay, thank you very much for all the presentation. Hopefully that what we share here it will be very valuable for us, and hopefully also can contribute to the development of international law in the future. Give applause to the three presenters. Okay, I think this time is up, so I would like to give her the floor for the committee. Thank you very much.
Thank you very much. Round of applause for our chairperson and speakers once again.